seek your Lordship's indulgence, Your Lordship. If I may be allowed to mention from part 2, item 4, if this matter may kindly come up in the week commencing 7th of April, Your Lordship.
My Lord, if a date may be fixed on in that particular week, 7th, the 7th of April, may it kindly be fixed.
What is the difficulty today? Otherwise,
The difficulty, Your Lordship, in fact, Your Lordship, since the beginning of Monday, we were waiting for this item 3. But then yesterday, because of the other item, which is supposed to continue on Monday also.
we will not fix a date. We'll just say a week commencing from so and so.
7th.
As paid for by counsel for the appellant and not objected to by the other side. Place this matter for hearing in the weekly hearing list commencing from 7th of April 2025.
I'm obliged.
What about 5?
5.
You are there in 5 also?
May I please, Your Lordship? My Lord, my senior has some personal difficulties. So if this matter may
Who?
be please taken up. Mr. Tila Lunsiama.
When?
Anytime next week,
If this matter may come up on Tuesday, Your Lordship,
on Tuesday.
25th.
All right, as paid for by the learned counsel for the parties, list this matter for hearing on 25th of March 2025.
I'm obliged.
Obliged.
I seek your Lordship indulgence in mentioning one unlisted item, my Lord. The reason why I'm mentioning is that there is a Supreme Court order, my Lord, which dismissed the SLP filed by the NPCC. Now there is an order of this court which says that the decision of the Supreme Court may be awaited. It is a case in contempt case 25 of 2021. So this may be kindly listed next week. Otherwise, it will not be listed because the registry has refused to list this case because there have some misinterpretation of the order. Because they say that the dairy number and the SLP number is not the same. So while on 31/25, the NPCC Council has stated that they have filed SLP, but they did not have that SLP number. They only have that dairy number. Now we have this SLP number and it was dismissed. So this matter can be listed.
What is the case that you wish to?
Contempt case, my Lord. Contempt case number 25 of 2021. So it may be listed any day next week.
You have a mentioned memo with you?
Yes, my Lord.
We'll have it on Monday. Monday.
Yes, my Lord. Obliged.
Give him back the order, Supreme Court order. You take back your order. Produce it on Monday.
My Lord, I have the extra copies. I can
It's
take
okay, take it back.
My Lord.
What will we do with that order?
Motion, item 1.
I appear for the petition, madam.
Yes.
But this is a matter under the Income Tax Act, my lord. But the issue in this petition is, my lord, that there is a assessment order passed against me I filed a revision against that order under section 264 of the Income Tax Act. Now that 264 order is not a further appealable order, so the only remedy lies is the remedy for the writ court, my lord. So that is why, my lord, this petition has been filed. But the issue, my lord, the issue in this petition is that under section 10, subsection 26 of the Income Tax Act, my lord, a member of the scheduled tribe from the state of Mizoram is entitled to exemption under the Income Tax Act. My lord, there are two more conditions that in addition to that member being the member of the scheduled tribe, see, the person must be permanent resident of the state of Mizoram, and also the income must accrue or arise from the state of Mizoram. So these are the three things. My lord, as far as I am concerned, I am a lady from the state of Lunglei. I have a
Not state of Lunglei, city of Lunglei.
city of Lunglei. Sorry, I apologize. District, Lunglei district.
Yes.
My lord, so, my lord, I have a wholesale and retail business of various FMCG products, tobacco products, dairy products, and also, my lord, the edible and food items. I purchase all my items from various multinationals like ITC, Adani Wilmar, and all that. I am regularly filing my GST returns. My GST returns are all accepted. There is no dispute about my GST returns. And all my earning is in cash. So, every day, at least 2 to 3 times a day, sometime once, sometime twice, sometime thrice, I deposit all my cash earning in my bank account. So, it is because of this large cash deposit, an inquiry was initiated against me to verify my source of income and all that. I submitted the balance sheet, the particulars, my certificate of the Deputy Commissioner of the Lunglei District, Deputy Commissioner, that I am a scheduled tribe, I am a member of the scheduled tribe, I am a permanent resident of the state of Mizoram, and also that I am entitled to income tax exemption under section 226. So whatever detail was possible, I submitted. Now, the assessing officer rejected my contention that my income has arose or accrues. They have a suspicion without any basis, without there being any investigation. They have never visited my premises, and my difficulty is that, my lord, now this 246 proceedings as well as my assessment proceeding, all the proceeding happens over the faceless, means I have to upload all the details over the internet, the portal. There is no physical interaction with the concerned officer. I do have a jurisdictional officer based in the state of Mizoram, but I cannot interact with my jurisdictional officer. Now the scheme of the assessment is such that it has to be conducted in a faceless manner. That means I cannot see the face of my assessing officer, nor my assessing officer can see me. All communication has to happen over the income tax portal. So whatever I could, I submitted. And the assessing officer has come to the conclusion that there is a suspicion that probably my income is not from the state of Mizoram. He is not disputing or doubting my being a member of the tribal community, or that I am not a resident of the state of Mizoram. All those things he is not doubting. The only thing is that he suspects that my income has not arose from the state of Mizoram. There is no basis whatsoever. There is nothing mentioned in the order. The only basis he is saying is that I have not submitted the details of the purchase, from whom I have purchased and all that. Now, my lord, to submit voluminous documents over the internet, there is a limitation of the size also, the number of documents. Another allegation he is making is that I am not maintaining books of accounts. Now, how he has come to that conclusion, I do not know, because he has not visited my place of business. He is neither it is possible for me, my lord, when I am conducting the retail transaction, where, my lord, probably thousands or maybe the number of transactions are many.
Okay, show me what have you impugned in your petition.
My lord, there are two orders, my lord.
Page,
The,
page,
my lord, page number is 307 onwards. This is the assessment order, the first assessment order against me. Well, 307 it starts. My lord, 313 is the operative part, my lord. Paragraph 4.4 onwards, my lord. Shall I read out, my lord?
yes.
Paragraph 4.4. The reply furnished by SSC had been perused carefully but found untenable and bereft of any merits. As per reply of SSC, she was engaged in the retail and wholesale distribution business of FMCG products in the name and style of LZ Traders. Part of cash deposits and bank accounts were out of her aforesaid business. With regard to such contention of SSC, it is pertinent to mention here that total credit entries aggregate to rupees 29 crores 85,052, which also includes cash deposit of 23 crore 10 lakh 84,723. Despite such huge value of financial transaction, the SSC failed to maintain the books of accounts, which is mandatory as envisaged in section 44AA of the Act, and also failed to get the books of accounts audited as per prescribed 44AB of the Act. Now, my lord, here I must point out they have not visited my place of business, they have not conducted any inquiry. Secondly, the SSC claimed in a reply that during the year she was engaged in retail and wholesale distribution business of FMCG products, and entire income was accrued and arose in the state of Mizoram, and claim exemption under section 1026 of the Act. Such contention of the SSC is not tenable due to lack of credible evidences. The SSC in support of such claim failed to furnish documentary evidence of purchase and sale of FMCG product, name and address of parties from whom the SSC made purchase, copy of bills and invoices in respect of purchase and sale of FMCG product. Likewise, SSC also failed to provide the details of the parties, their ledger accounts and cross confirmation to whom sales have been made. Therefore, in the absence of aforesaid details and evidences, the claim of exemption under 1026 of the Act and income earned thereon the deposit of cash in the bank account remain unverified. The SSC should have to furnish the aforesaid basic documentary requirement under the Income Tax Act to substantiate the claim of exemption under 1026 of the Act, and accordingly the claim is hereby rejected. SSC contended that the part of cash deposit pertained to her sister so and so, as she also has a firm in the name of Messrs. LZ Agency, as they both use same account in the business operation. Such contention of the SSC is also untenable, as SSC failed to furnish even an iota of documentary evidence to substantiate her claim. The SSC is an individual and has filed original return of income on so and so date declaring total income at ₹0. The SSC's case was selected under cash for complete scrutiny for following reason. Large cash deposit, turnover in the ITR is substantially lower than the turnover shown in 9C, claim of large exempt income. On perusal of ROI for the year under consideration, it was noticed that the SSC had claim exemption under section 1020 at the rupees 289,56,255. Further, on verification of reply and bank statement furnished by the SSC, it is seen that the total credit entries appearing in the 3 bank accounts, including the cash deposits, come to 29 crore 85,052. Therefore, while so-called notice dated so and so, SSC was requested to substantiate the source of cash deposit made during the year and to verify the large exemption claimed by the SSC and her return of income. In response to the final so-called notice dated so and so, the SSC filed response and so and so. SSC in her response has stated that she is an individual resident of Lunglei, Mizoram. SSC further stated that instead of exempt income of 28,95,625, she has wrongly claimed exemption of 289,56,255 in her return of income. SSC further stated that her sister so-and-so also having a firm in the name of so-and-so, and they both use same bank account for depositing cash collected from their sales. Therefore, as per reply furnished by the SSC, cash deposit reported by bank is 3309.78 lakhs, which is more than her sales reported as per GST. To substantiate her claim, SSC had attached copy of Temps exemption and tribal certificate. Details and place of business. So details of place on business I have submitted. Copy of bank statement for the relevant period. And copy of her ID proof among the other details. The reply furnished by the SSC had been perused carefully, but found untenable and bereft of any merits. As per reply of the SSC, kindly just see, to substantiate, I have submitted copy of tax exemption certificate, tribal certificate, details and place of business, bank statement, ID proof, among other details. As
So-
per reply of the
So what is the ultimate conclusion then?
My lord, the ultimate conclusion is that
Penalty proceedings have been initiated.
penalty proceeding also initiated, and they have also initiated recovery proceeding against me, my lord.
Where is that?
My lord, the recovery proceeding is on page, my lord, recovery proceeding, recovery notice dated 22/5/24, page 329. That is the first letter, page 329. And one more letter, my lord, page 339, dated 29/24. My lord, on page 388, I have furnished a chartered accountant certificate also, my lord. Page 388, my lord. But kindly have a look. Page 388. But the certificate says that the proprietor of business so-and-so is a local Mizo girl who belongs to Mizo community, is recognized as scheduled tribe as defined in Article 366 of the Constitution, that she is not required to pay income tax by virtue of 1026 of the Indian Income Tax Act. Notification number so-and-so issued by the Government of Assam and Northeastern Reorganization, adaptation of laws on Union Subjects Orders 1974, insofar her income within Mizoram is concerned from the above stated business. That Messer so-and-so is registered under GST law, wide registration number so-and-so, with their principal place of business at the above stated address only. That the above business has been in existence for 15 years and was also registered under the Mizoram Value Added Tax Act and Central Sales Tax Act, wide registration number so-and-so. That the business of the activities of the above concern are trading into FMCG products, dairy products, tobacco products, edible and food items, etc. of the reputed brands of India. That the business turnover derived from the above stated business during the period and reported under GST and income tax was 16 crore 58,55,746, plus taxes thereon as per the GST return filed was CGST 1 crore 11 lakh 67,355, SGST 1 crore 11 lakh 67,355, and cess is 573,02,705. Malad, the reason between the difference in the GST turnover and the bank turnover is because of the tax amount. The tax amount is very huge, my lord. The cess itself is 5 crore 73 lakh. Thus, the total sales received including of taxes was 24,54,93,163. So, what is deposited in the bank account is, including tax. That the main bank account of the aforesaid business was lying with Mizoram Rural Bank, Lunglei branch, so-and-so account, wherein the above business turnover was deposited along with the turnover of one Messrs. LZ agency also, deals in similar products, and the business is owned by proprietor sister so-and-so, who has a separate GST number for a business but maintained a common bank account for both businesses. That the turnover of LZ agency for the period 21-22 as per GST annual return was so-and-so, plus taxes thereon as per the GST return filed was so-and-so. Thus, the total received inclusive of taxes was 12,88,39,561. and the total turnover has been bifurcated. The total turnover of both the firms are 37 crore 43, 32, 725. But I also wish to draw your attention to the some sample copy of the invoices which I have annexed to this petition, my lord, which is on, my lord, the page 349. But kindly have a look at page 355, my lord, for once, the e-way bill. Place of delivery is Lunglei. My lord, my lord, this e-way bill is on the portal, my lord. Everything is happening on the government portal. So, my lord, I cannot manipulate all these data that the goods have been delivered to me in the Lunglei district. My lord, I calculated and checked from the portal, my lord, the nearest distance, my lord, from the place of this Lunglei district to outside the state of Mizoram is around 35 kilometers. She is getting her purchases in Lunglei district, then how can she sell it outside the state of Mizoram?
Okay, 307 is the assessment order.
Then, my lord, this order under section 264 is also, my lord, kindly have a look, 342, which is the impugned order. 342, this is the
342.
revisional order. 342, my lord.
Hmm.
In this case, shall I read out, my lord?
What is the date of the order?
Well, the date of the order is 30th of December 2024.
Is this the last order passed?
Yes, my lord.
This is passed by the
With the Principal Commissioner of Income Tax, my lord.
Principal Commissioner. Order under 264.
Yes, my lord.
Prior to this, what was the order?
Prior to that, my lord, that order, assessment order, my lord, that I have.
Page?
That is on page
Page
307
307.
onwards. 307 onwards.
Initially, assessment order was passed on this 19/3/24.
Yes, my lord, correct.
This was confirmed
and that
this was-
was confirmed by this order, my lord.
by this order,
30th December.
30/12/2024.
Correct, my lord.
And in between the process was this, what do you call,
Recovery notice. my lord.
recovery notice.
Yes,
There were two recovery notices.
Two recovery notices. And a penalty proceeding also, my lord.
Where is that penalty proceeding?
Lord, the notice for penalty is on
It-
page
it-
322. And my lord, the page 68, my lord, is the tax exemption certificate, my lord.
Okay, see, it started with the assessment order.
Yes, my lord.
Then the assessment order says that you have failed to explain
Yes, my lord.
your source of income.
My lord, they have, my lord, they have noted down the documents which I have submitted. Now, why those documents are not credible, that they have never discussed.
Okay.
Those documents, my lord, probably not considered also.
Okay.
But they are referring to some other documents
All
which
right,
is
all
not
right.
submitted.
Right now, I'm concerned with the process.
Yes, my lord.
First the assessment order,
Yes, my lord.
then followed by the,
My lord, the revision order under 264, my lord, 342, my lord, page.
before that, there was a notice for penalty also.
Notice for penalty also.
Then thereafter, the notice for recovery of the outstanding
Yes, my lord.
on 2 occasions.
Yes, my lord.
Then finally came the order of 264.
Yes, my lord.
So what is the penalty imposed upon you and what is the penalty?
But the penalty is as of now at the proposal stage, my lord. My lord, that is, my lord, the proceeding has been initiated. Page 322.
322.
Yes, my lord. This is a notice for initiation of the proceeding, my lord.
This was way back in 19th of March 24.
Yes, my lord.
So what is the status of this
But
proceeding?
this, they have taken a adjournment, they filed a reply dated 3/4, page 324.
Who has filed the reply?
But the SSE, the petitioner.
Then, after the reply,
But after the reply, my lord, they have sent another notice for penalty, so-called notice for penalty, that is on 326, my lord.
okay. Then,
Thereafter, my lord, it is, my lord, no further proceeding has happened after my lord, this particular notice, my lord.
almost a year now.
Almost a year, my lord.
So why have you come now?
No, my lord, I have come against the order dated 30th December 24, my lord. That is the, because I was, my lord, entitled to pursue my remedy under 264. So I was, my lord, because, my lord, if my assessment order goes, my lord, then all the proceedings are consequential. The penalty proceeding
This 264 order was passed on your application.
on my application.
You applied for the...
Yes, my lord, correct.
Recalling-
342, my lord, it is noted in the order. Shall I read out, my lord? It's a small order.
No, it's okay. At this stage, what can be done? We'll have to issue notice, that's all.
My lord, kindly, my lord, the demand is of 28 crore, my lord. They are initiating the, my lord, kindly stay the proceeding, my lord. till
Where is the demand?
my lord, the computation sheet is on page 318.
318.
The total amount, my lord, the identified, my lord, 321 is the amount payable. 28 crore 5 lakh 63 777.
Where is that?
My lord, page 321, my lord, column number 63.
Any time frame has been prescribed for this
Time frame for, my lord, this payment?
payment?
No, my lord, the time, my lord, unless, my lord, I am pursuing any further remedy. It is always, my lord, subject to further remedy. Like I chose to go for 264.
After 264, what?
After 264, the only remedy is, my lord, the writ code. There is no, because it is passed by the principal commissioner. So there is no appellate, because this is the highest authority in the,
Okay, the amount payable and refundable has been computed already. Okay.
yes, my lord.
And there's no time frame for payment of this?
There is no time frame as such, but since, my lord, as far as 264 proceeding is concerned, unless
That's
your,
over. That's over. 264 is over.
that is over, my lord.
Was
Now
rejected.
I am before your lordship.
It was rejected. So the authorities will wait until you exhaust all the remedies.
My lord, they
This-
will, my lord, unless it is state, they will not wait, my lord. Unless your
So
lordship
that's
is,
why I'm saying,
yes, my lord.
is there any
It has
time
to
frame
be
fixed
state, my lord.
that you have to deposit this amount which
Yes,
has
my
been
lord.
assessed?
Unless, my lord, unless it is state, my lord, they will recover, my lord.
No,
They will,
stay is a different thing. Recovery will take place when?
they have already initiated, my lord. I have shown 2 letters of the recovery, my lord.
But
Even though they are prior to, my lord, this order under 264, but since the order under 264 has been passed against me, So those recovery letters are still valid, my lord. They may initiate and, my lord, they are pursuing me. And they may attach my bank account and my property, my lord, everything will come to an standstill.
What is your good name?
My name is Vinay Saraf, my lord.
Sorry?
Vinay, VINAY,
Heard Mr. Vinay Sharaf, learned counsel for the petitioner, who submits that by filing this writ petition, the petitioner has challenged the assessment order dated 19/3/2024. Comma, the amount computed by the respondent authorities
Well, it is 28 crore 5,63,777. Page 3.
as per the computation sheet dated 19/3/24, 2024, amounting to rupees 28,05,63,777. Comma, the notice for penalty under section 274 read with 271 capital AA capital C bracket 1 of the Income Tax Act, comma 1961 bracket the Act close bracket, the recovery notices dated 25/2024 and 29/2024, and also the order passed by the Principal Commissioner of Income Tax under Section 264 of the Act, dated 30/12/2024. To stop next para, the learned counsel submits that the petitioner is a resident of Lunglei in the state of Mizoram, and she is engaged in retail and wholesale distribution business of FMCG products in the name and style of LZ Traders. And part of cash deposits in bank accounts were out of her aforesaid business. Stop. The respondent authorities, upon noticing large number of transactions happening in our bank account, had initiated the process, despite the petitioner having claimed that she is exempted under section 10 bracket 26 of the Act. Full stop. The learned counsel submits that the impugned proceedings the assessment order has been passed without considering the the documents and the explanations tendered by the petitioner. Stop having no alternative after the passing of the order dated 30/12/2024 under section 264 of the Act. The petition is before this court. Stop. The learned counsel submits that unless some protection is given to the petitioner pending disposal of the writ petition, the petitioner is bound to suffer irreparable loss and hardship in view of the assessment, in view of the amount computed and assessed for the petitioner to refund in terms of the assessment dated
19/3/24.
19/3/2024. We'll stop. Next para, in view of above, issue notice of motion. Who are the respondents here?
The respondent is Union of India and the Principal Commissioner and the Assessing Officer who passed the order, my lord. And the state of Mizoram also is.
Stop. Ms. Zaidam Sankui, learned CGC, accepts notice on behalf of respondent
Number 1.
number 1, while Ms. Caroline K. Lungoipui, learned government advocate, accepts notice on behalf of
Respondent number 6, my lord.
respondent number 6. Stop. As such, no formal notice is required on respondent number 1 and 6. Stop. Petitioner shall, however, furnish requisite extra copy of the writ petition to the learned counsels appearing today. Stop. Petitioner to take steps for service of notice upon the remaining respondents by registered post with ADD within 3 working days. Next para, having regard to the projection made by the petitioner, it is provided here in the interim that the respondents it is provided herein that the assessment dated 19/3/2024 for making a refund of rupees, that amount I've given you, okay?
For making
Shall-
a, not
shall-
refund, my lord, payment of.
For payment of so-and-so, amount, you have the figure, shall remain state till the next returnable date.
But the order under section 264 also, my lord, that is 30/12/24. Because that is the last order, my lord. Order under 264, my lord. Page 342, my lord.
264 merely confirms the earlier order of 19/3,
yes,
isn't it?
Yes, my lord.
Likewise, the impugn orders dated 19/3/2024, as well as the order dated 30/12/2024, bracket annexure T and annexure FF, respectively, shall also remain state till the next returnable date.
Grateful, my lord. Grateful. my lord. Will your lordship be giving any specific date or we have to, my lord, in
You are coming from
Calcutta, my lord?
Calcutta.
Yes, my lord.
I said 4 weeks, so we can have a date if you want to.
My lord, if your lordship can give a date, my lord, I would be grateful, my lord. After 4 weeks, my lord?
What is 28? It's a holiday? It's a Monday, okay. List the matter again on 5th of May.
5th of May, my lord, I have some personal difficulty on 5th of
So
May.
you tell me what date is convenient after 4 weeks?
Because 5th of May, my lord, the vacation starts in, no, 5th of May is fine, my lord. 5th of May is fine.
Vacation there, we are working here.
No, because if we have a vacation there, then we just generally go out with family. 5th of May is fine. 5th of May.
You can come here
No, 5th of May is fine.
with the family.
Yes, yes. Next time, that is what my wife was telling me, that she wants to come next time.
List again on 5th of May.
Grateful, man.
Item 2.
Yes, Mr.
Your
Mr.
Lordship,
Dinari.
this petitioner, there are 10 of them, and they are possessing the respective lands between Latur village and Maisa village within Siha district. And their land was, over their land they have constructed a road by the BRTF for maintenance of national security along Indo-Myanmar international border. And preliminary notification was published on 17/5/2017.
What is the name of the road?
The road is
Kau Chau,
Kocho
Kau Chau, Pura, Tokalo.
Yes, Tokalo, KPT road, they have said.
This is the stretch of the road.
Stretch of the road, 30 to 45.
Only 5 kilometers. No, only 15 kilometers.
Yes,
15 kilometers only.
yes. And Your Lordship, the respondent awarded, have made an award or a draft award 4 of 2021, wherein they have deducted 10% of assess on the basis of the MIDC rules, and the interest is not calculated from the date of possession. So that is, even though Your Lordship, as you know, you have passed similar or similar to this case, you have passed judgment and order, wherein Your Lordship kindly see page Annex 7, page 34. Operative portion only read page 46, Your Lordship.
Yes.
Here, 1. The Act of 2018 does not contemplate deduction of cess from the compensation to be received by the landowners, and therefore deduction of cess made from the amount to be received by the petitioner is only illegal. Hence, the amount so deducted should be refunded to them within a period of 2 months from the date of receipt of a certified copy of this order. The district collector concerned shall determine the date of taking over possession of the land of petitioners after giving them due opportunity of hearing along with the BRTF authorities within a period of 2 months. Upon such determination, the collector shall assess the amount of interest payable to the petitioners and forward the same to the Respondent Union of India, who shall, upon receipt of the same, within a period of 2 months, deposit the amount so assessed before the collector for disbursement to the landowners. The state respondent shall, within the period of 3 months from the date of receipt of a certified copy of this order, establish Land Acquisition, Rehabilitation, Resettlement Authority in terms of Chapter 8 of the Act of 2013. Once the same is established, any person interested and who has not accepted the award may make a reference in terms of Section 64 of the Act of 2013, and applications so made shall be considered in accordance with law. So, Your Lordship,
This case
yes,
was in respect of
same road, Your Lordship.
same award.
The award,
What is the award number?
the award numbers here,
The award number is not reflected. I think.
reflected. I'll come to that, Your Lordship. These orders complied. Kindly see the next page, 48.
What about the reference?
Reference is not yet established.
Not yet established.
Yeah.
Okay.
Interest, yeah.
In this judgment, we have written Kolso, Pura and Tangkolong.
Yes.
But
same
in this
road.
case, It's written as Koa Chau
Yes,
Pura
yeah.
Tokalo.
Sometimes they call Kocho.
This is in Mara?
Yeah, Mara.
This is Mara language.
Mara language.
Okay.
Same road.
Okay.
And the next page is the payment of cess.
So, you're not sure about the award number on this case?
Yeah, here, this case, what number is 4 of 2021?
No, the judgment which you just read.
I
You don't remember?
forgot. I'm not sure.
Okay,
Is it same
then
or not?
the subsequent order passed by this court,
Yes, subsequent
At
order
page
passed by
52.
this court and the award is same. The
52,
present, yes,
page 52, the award
Yeah.
is the same.
same, Your Lordship. You
It
are
says draft award,
draft award, they say.
but here you say award.
Yes, draft award,
Draft award and award is different or same?
same, Your Lordship. 21 of, award number 4 of 2021. Your Lordship, inadvertently, we omitted these 10 persons while filing the WPC number 138 of 2024. So it's clearly covered with this judgment.
How
The
do you
pres-
say omitted inadvertently?
They gave us the name, but they forgot to include in the petition.
I see. Yes, government and CGC,
With regards to the, there is an appeal which is lying before the division bench, Your Lordship.
appeal.
Yes, Your Lordship.
No,
Which
it's
one?
complied.
Which
some-
case, which appeal? Where's the appeal?
Written number 2 of 2025, Your Lordship.
Against which order?
This is against the order dated 21/11/2024, passing WPC 103/2024.
21/11,
2024.
passed in
WPC number 103/2023.
Your Lordship, so far as my knowledge, the appeal is filed by MIDC. However, district collector complied the judgment and order. Whatever says calculated where it's about 20 lakhs were paid to the landowners, which was with them.
You have enclosed that letter, I've seen it.
Yeah.
See, what is the writ appeal number?
Written number 2 of 2020.
There is no stay order also.
2 of?
2 of 2025, Lordship. And there are other 2 as well, with appeals as well.
Preferred by whom? MADC?
Yes, Lord. Yes, Lordship.
State has not preferred.
No.
No, Your Lordship.
Okay.
Then
What is the status of this appeal? Status of the appeal?
Notice was issued, stay is not given.
Notice has been issued.
Delay notice was issued. Notice was issued. The judgment is not stay at this stage.
So what is to be done then?
Your Lordship, if the judgment is not stay and some part of the judgment also complied by the district collector, so then it can be a covered case. There is no stay order. Even though they have filed appeal.
This writ petition, WPC number 138 of 2024, it was disposed of after the filing of the writ appeal or before filing of the writ appeal?
I don't know when they filed the appeal. We have not received the copy of the appeal also. Now, it was some delays.
Okay, what about the MADC? Were they not a party in this 138
They were a party, Your Lordship.
as a respondent?
Respondent here. Yes, Your Lordship, there are 5 and 6.
They were not represented on that day. See, what you have done is you have annexed the first page
Here,
and
yes.
page 2 to 11 are missing.
2 to 11. The judgment, I mean,
Yes, yes. Page 51 and 52.
51 and 52. Okay.
So after 51,
Oh, hey,
there has to be the name of parties. All those things are there. That has been omitted.
yes.
Straight away you have annexed the order. So we don't know who's appeared for the MADC.
So if I'm not mistaken, Your Lordship, there are 5 and 6 in the same.
Was it disposed at the motion stage?
Yes, I have a loose copy. There are 5 and 6, Your Lordship. This is the complete. Okay. And yeah, 138. MLDC have no standing counsel, that's all.
So this writ petition, 138,
Yes,
it was disposed of at the motion stage? Or what?
yes,
But one thing is there now, see, since we know there's an appeal pending, let us issue notice at this stage.
fine. But the stay is not there.
I understand, stay is not there, but let notice go. We'll see. Let them at least appear and we'll say we can pass necessary orders when they appear. Please write down, heard Ms. Dinari T. Azul, Learned Counsel for the petitioners, who submits that by filing this writ petition, the petitioners seek for a direction to the respondent authorities concerned to refund 10% of the awarded compensation deducted by them towards cess. Any other direction you're seeking? Okay.
interest.
Yes, the petitioner, she submits that the petitioners also seek for a direction to the respondents for assessing the interest payable
From the date of possession.
from the date of possession. That is 17/5?
17.
17/5/2017, comma, on which date a preliminary notification under section 11 of the Mizoram bracket open Land Acquisition, Rehabilitation and Settlement close bracket Act, comma, 2016 was issued. To stop, she submits that the respondent authority concerned has calculated interest only with effect from 13/8/2018. What is this date, 13/8/2018?
13/8/2008, they have made.
Okay, under the
again
2013
another,
Act.
Yes.
13 Act, okay, 13/8/2018, which was the date on which a notification under section 11 bracket 1 was issued under the what is this, right to fair compensation
Yes.
uh,
RFS.
and transparency in land acquisition, rehabilitation and resettlement act, 2013, bracket act of 2013. And before that 2016, you also write act of 2016. Next para, the learned counsel submits that the case of the petitioners is squarely covered by the judgment and order rendered by this court on 21/11/2024 in WPC number 103 of 2023, and the order dated 31/1/2025 passed in WPC number 138 of 2024. Stop. The learned counsel submits that the case of the present petition is no, you cancel that. The learned counsel submits that in fact, the judgment and order dated 21/11/2024 has been complied with by the respondent authorities by refunding the assessed amount to the concerned petitioners. Full stop. She therefore submits that
Your
yes,
Lordship, interest also calculated and forwarded to the BRTF.
what did I say? Forwarded as before that. Stop. Okay. She also submits that the interest has also been calculated by the district collector, and the assessed amount has also been forwarded to the BRTF authorities for payment. To stop. She thus submits that a similar direction will be passed in the instant case. Next para, it is submitted at the bar that writ appeal number 2 of 2025 has been preferred by the Marathoners District Council against the judgment and order dated 21/11/2024 passed in WPC number 103 of 2023. But what did I say? It is submitted at the bar. Stop. Mrs. Dinari T. Azul, learned counsel, however, submits that there is no stay of the judgment impugned, and therefore there is no impediment in passing a similar direction in the instant case. Next para, in view of above, issue notice of motion returnable by 3 weeks. Mrs. Adam Sankoi, learned CGC, accepts notice on behalf of respondent.
Number 1 and 2.
Respondent numbers
1 and 2.
1 and 2. While Ms. Lalnon Louis, learned government advocate, accepts notice on behalf of respondent number 3 and 4.
Your Lordship, that's the date, 23rd of April.
Petitioner to take steps for service of notice upon respondent numbers 5 and 6.
Yes.
Can you serve by Dusty?
Dusty also you can do it.
Additionally, the petitioner is permitted to serve notice to respondent number 5 and 6 by way of Dusty through the registry of this court within 10 days. An affidavit shall be filed thereafter as proof of service. List the matter again. When?
23rd, Your Lordship, April, after holiday.
23rd April.
Yes.
Okay. What's the matter again on 23rd of April?
Okay.
Yes.
Item 6.
Yes.
May it please Your Lordship, this IA has been filed for deleting the respondent number 1 and 4, for deleting the respondent number 1 and 4 from the array of parties, Your Lordship.
1 and 4.
Yes, Your Lordship.
Who are they?
Your Lordship, 1 is Forest Department and 4 is SP Serchip, Mizoram.
1 and 4. Forest and then who will remain? Deputy Commissioner, Kala and
And General Manager, NHIDCL.
what is this matter regarding?
Your Lordship, this matter is actually regarding an order passed against the petitioner for eviction with regards to their building within LSC number so-and-so located at Conveying Serchip, Mizoram. So there was a detailment order which was passed,
Eviction passed by?
a detailment order for eviction passed by the DC Kala, Your Lordship.
Where
It
is that?
On,
Page?
on page number 9, Your Lordship.
So why do you want the deletion of this respondents?
Your Lordship,
Page number 9
yes, Your Lordship, page number 9 of the
of
IA.
IA.
Yes, Your Lordship.
9 of the IA.
If I may, Your Lordship, the copies have been given to the Forest Department and also to serial number 3, the SP Serchip. So, Your Lordship, the Forest Department actually conducted a spot verification and they have noticed that the area concerned does not fall within any plantation area nor under any reserve forest area. So, they have said that they have no submission or any, they will not be contesting this matter in this matter, Your Lordship. And then with regards to the SP, Your Lordship, even though it was given for to detail the police personnel for eviction, Your Lordship, at this point, on the 5th of July 2024, a stay was granted against the detailment order, Your Lordship. So at this point, Your Lordship, there is no law and order to maintain as such, nor is there any eviction in place. And they have neither contested the case as well, Your Lordship.
So what is the stage of the writ petition otherwise? Affidavits have been exchanged?
My Lord, yes, the affidavit has been filed by the NHIDCL and the Kala.
I'm for the respondent number 2, Kala.
Yeah, for the Kala. Yes. And who else has filed?
Only 2, my Lord.
Sorry?
2 and 3.
Respondent number 3 has filed affidavit in opposition.
Who's respondent number 3?
NHIDCL.
Okay, NHIDCL has filed and Kala also has filed.
Yes, Your Lordship.
So matter can be taken up for hearing, isn't it?
Yes.
What do you say about the application
I have no objection, Your Lordship.
No objection from our side also, my Lord.
for deleting them?
My Lord, because they were implemented, because they were given a copy of the demolition drive order by the DC, by the Kala. So they were implemented.
Supposing your writ petition is dismissed, then they will have to carry out the demolition.
My Lord,
So why should we delete them?
But my lord, they are not the officials who have initiated the demolition drive.
Then why did you make them a party in the first place?
First,
If you have no objection today? Huh?
that's already pointed out by the applicants.
After you got the stay order, you feel that the purpose has been served, so you want them to go away. Is it like that?
My lord, actually the writ petition is not against them.
Your Lordship, there are no averments made against the
No, that's
respondent.
okay, but there will be no such kind of adverse orders to be passed against them. They are a party to that because by virtue of their official capacity that we are not impeding anybody by name. All right, if they have no objection, we'll dispose it of them. Heard Ms. Louis, learned government advocate for the applicant who submits that by filing this application, the respondent number. Who has filed this application?
Your Lordship, it has been filed on behalf of respondent number 1 and 4, Your Lordship.
No. Your format is also wrong. What kind of application is this? Who is the applicant?
I am the applicant, Your Lordship.
Where in the cost title? Nobody is shown here.
Your Lordship,
Who's
the secretary has, under secretary FNCC has signed.
Oh, he may have signed it, but I'm talking about the cost title. This is not the way to file the application. You have to mention all the names of the respondents as applicants,
Yes, Your Lordship.
or if not, at least the number 1 and number 4. We cannot pass any order like this. Have you understood what I'm saying?
Yes, Your Lordship.
Then you file a fresh one. You
Yes,
withdraw
Your
this and file a fresh one.
Yes, Your Lordship.
Make them a party applicants. These are the applicants. Then again you go to the next step saying that these are the petitioners, these are the respondents. Then you say that this application is filed by 1 and 4
Yes, Your Lordship.
for withdrawal of their names. For deletion of them as a party respondent.
Your Lordship, if I may, even if they're not struck out from the cause title, no adverse order is going to be passed
That's
against them.
exactly what I was saying.
Yes, as you stated, yes. So if the matter may be taken up for hearing, listed for hearing, because the...
You will not be contesting it anyway, Your Lordship. The respondent number 1 and 4 will not be contesting the matter.
So okay.
So it makes no difference.
If you still want them to be deleted, you have to file a fresh one.
Yes, it will just
Because
cause
I don't intend to pass any such kind of orders here.
cause delay in the course of the proceedings.
Unless it's in proper form, it will be difficult. Because others will follow example. They say, in that case also, there was nothing there, but court passed the order allowing the application.
So, Your Lordship, if I may humbly propose, it is at the discretion of the court. If
No, what I'm saying is that if you want to, you withdraw it and file afresh.
I will withdraw, Your Lordship.
Okay. On the request of Ms. Louis, learned government advocate, the application stands disposed of as withdrawn. However, liberty is given to file a fresh one if so advised.
Much obliged.
Then in the main writ petition, you write, the parties are represented by the respective councils and they submit that the pleadings are complete and the matter can be posted for admission hearing. In view of above, list this matter after, when?
If possible next week also.
After a week
Much obliged.
in the admission column.
Item 7.
May it please your lordship, I am appearing on behalf of my senior, Mr. Johnny L. Tochong, who is the departmental counsel. He instructed me that he has some personal difficulties, so if this matter may be taken up on another time.
What is your good name?
Michael Patswell.
So you accept notice on his behalf of Johnny? Mr.
Yes,
Johnny?
yes, Your Lordship.
Today, what can be done? We can only at best issue notice, that's all. We cannot straight away start hearing the matter. Yes, what is your case?
Your Lordship, this is a bail petition filed by the petitioner in connection with seizure of 4,378 grams of suspected methamphetamine at Hotel Sancte Truampui on 4th July 2023. And in the present case, the petitioner was one of the accused person, and the case was registered under registered as custom case number 01/CL-NDNPS ASA 23 dated 4/7/2023 under section 22C and /23C of NDNPS Act. Your Lordship, the petitioner earlier submitted a true bail petition before the Lanet Special Court, the Lanet Trial Court, but both of them have been rejected, and therefore...
How many accused person?
True.
2 accused person. You're one of them.
Yes.
What has happened to the other? He's also in custody.
Yes, he is already, he is also in
This drugs have been caught from your possession?
Actually, it is not from the physical position, but while I was staying at the hotel, they come to our hotel room, and the essay was seized from the floor near the bathroom.
In your room where you are staying?
Yes.
Okay. So how did it happen to be there?
Your Lordship, in the present case...
Unless you brought it in yourself.
The mandatory provision of Section 42 has been grossly violated in the present case.
42?
Yes, Your Lordship.
Search and seizure? Search and seizure.
Yes, Your Lordship. There was no authorization, no search warrant. It was night time. It was after sunset, and there was no grounds of belief recorded in the present case. Even if the hotel itself may be a public place, but the room occupied by the petitioner was not a public place. And
Okay.
therefore,
What is the stage of the trial?
the prosecution examined 6 witnesses out of 10.
Okay.
And the petitioner has been already detained in judicial custody for 3 months, 1 and 10 months.
Huh?
1 year and 10 months.
Okay. 6 out of 10 prosecution witness examined.
Yes.
4 remaining. Who are they 4?
The prosecution,
Where's the charge sheet?
the charge sheet is page 13.
13?
Yes.
30?
1-3.
1-3. So let us see how many witnesses are there. Can you tell us who are the persons who have been examined already?
Already examined are PW 1 through 3, 6, 8, and 9.
1, 2, 3, 6, 8, and 9.
Yes. The
Then-
remaining witnesses are 4, 5, 7, and 10.
JMFC, then the forensic, then what is this? Inspector Bongkon Police. Then what is this? Must be Caesar witness. Number 10 is a Caesar witness.
Yes. PW7 has been already summoned for at least 4 times, and he is not yet appeared before the court till date.
Can you pray for dropping his name before the special court?
I have already prayed for
Then
dropping, but the court refused.
the court refused.
Yes, another time may be called at least.
Okay. So when is the next date fixed? Short date. Okay, anyway, we'll issue notice today.
Yes.
Your good name?
Lilton Puya.
Art Mr. Lal Chanpuya, learned counsel for the applicant who submits that by filing this application under section 483 of the BNSS. (2023), read with section 37 of the NDNPS Act, comma, the petitioner prays for his release on bail. Full stop. He submits that the petitioner was arrested on 4/7/2023 in connection with recovery of 4,378 grams of suspected methamphetamine at Hotel Sangtea at Tuampui, Aizawl. Stop. Accordingly, custom case number 1/CL/NDNPS/AS-AZL/23 dated 4/7/2023 under section 22(C/23(C) of the NDNPS Act was registered and investigated into. Full stop. He submits that charge sheet has since been filed and trial is underway. Stop. That out of 10 prosecution witnesses, 6 prosecution witnesses have already been examined. But for one reason or the other, the other witnesses importantly, other witness, for one reason or the other, PW7 has not turned up on several occasions. And in the meantime, the petitioner has been lingering in custody for the last 1 year and 10 months. To stop, the Learned Counsel submits that the petitioner earlier approached the special court with 2 bail applications, but both the applications were dismissed. To stop, the Learned Counsel submits that there has been gross violation of section 42 of the NDNPS Act, and that the arresting authority has failed to record the grounds of belief prior to making search and arrest. And therefore, pending conclusion of the trial, the petitioner should be released on bail. Next para, in view of above, issue notice returnable by.
Your Lordship, it may, if the matter may be taken on 28 or 27. 27 or 28 of this month.
What do you say, Mr. Michael?
I have no objection regarding that, Your Lordship. 27.
Ten 28 will be too short a date, I think. We'll have it on 1st of April. Returnable by 1st of April 2025. Mr. Michael Pacho, Learned Counsel, accepts notice on behalf of Mr. Johnny L. Tochong. Learned, what is he? Mr. Johnny will be?
Departmental Counsel, Your Lordship.
Departmental Counsel for the Customs.
Yes, Your Lordship.
Petitioner to serve requisite copies of the bail application to the Learned, to Mr. Michael Pacho. Have you served?
Yes, already, sir.
Already served, Your Lordship.
Okay. If not already done. List accordingly. Registry to list accordingly. The case accordingly.
Much obliged.
Admission item 3.
My Lord, to Today morning, the petitioner counsel Emmanuel Trazuela has requested me because he is indisposed. He asked me to submit that they will be filing the reply affidavit within 3 days, 3 working days.
You're Mr. Ram Murmu.
Yes,
Mr. Ram Murmu, appearing on behalf of Mr. Emmanuel Lal Thazwala, learned counsel for the petitioner, submits that the reply affidavit of the petitioner will be filed within 3 days.
Yes.
And therefore, time may be granted.
Yes.
Full stop. In view of above, list the matter again.
On possible 21st of April.
21st of what?
April, but it's holiday.
Why?
They have requested me for 21st of April.
Your Lordship, 21st is a holiday.
Yes, it's a holiday.
You want to come on holiday?
No.
Then? You
After
are welcome to come,
22nd also
but there will be no
possible.
court.
Yes.
Okay. As paid for, list the matter on 22nd of April.
Much obliged, Your Lordship.
Item 4.
My lord, I already filed my affidavit.
Good. Then? Everyone has filed affidavit?
My lord.
May it please your lordships.
Yes.
Lordships, there was a last order of 7th of February, my lord. Whether the state government has filed any affidavit, a copy has been served on us, but whether that has been brought on record or not, my lord, they were directed to verify, my lord.
State respondents, respondent numbers?
Respondents number, my lord, 1, 6, and 7.
Have you filed?
We have already filed, but, my lord, we will take necessary steps. We will clarify to them, my lord. It was filed on 13/12/2024, my lord. Actually, my lord, this case has been taken up by Mr. Shriyata. So, as far as my knowledge is concerned, the affidavit was filed on 13/12/2024, my lord.
It is here on board.
My.
Affidavit filed by 1, 8, and 9. Then affidavit filed by 1, 6, and 7. Then this is affidavit. Okay. How many affidavits have you filed? 1, 6, and 7.
My lord, it's supposed to be 2, 6, and 7, my lord.
Then why did you write 1, 6, and 7? These are two separate
my lord, I
affidavits.
believe that is an inadvertent mistake, my lord. It is supposed to be 2, 6, and 7, my lord.
One is Union of India, my lord, so it has to be 2, 6, and 7, my lord.
So, what to do about it? 2, 6, and 7. This is what? An affidavit in opposition,
My lord.
then affidavit in reply to the additional affidavit filed by state respondent. You have filed additional affidavit also, state?
Yes, my lord. Yes, my lord. We have brought on record certain sale leads, my lord, by way of the additional affidavit.
No, petitioner has filed additional affidavit.
Yes, my lord. Yes, my lord. The second affidavit is the reply to the additional affidavit filed by us, my lord.
Okay, okay. This is by the state, okay. So it
And,
should be one, it should be 2,
Union of
6, and
India,
7.
I'm told, my lord, by my colleague, Mr. Subedi, that they have served a copy. He has received a copy on my behalf today morning, my lord. I'd like to go through that affidavit filed by the
Who has
Union of
received
India.
on your behalf?
Mr. Subedi received it
Subedi,
on my
okay. Okay. Please write, Mr. P.D. Nair, learned counsel for the petitioners, appears through VC and submits that a copy of the affidavit in opposition has been filed by the state respondents, but he's yet to go through the same, and therefore he prays for some time. Stop. Mr. Benjamin Laltham, learned government advocate, submits that although the cause title of the affidavit in opposition filed by the state respondents reads as affidavit in opposition filed on behalf of respondent numbers 1, 6, and 7, but the same should be respondent numbers 2, 6, and 7. Stop. Therefore, the affidavit shall be accepted as an affidavit filed by respondent numbers 2, 6, and 7. Okay?
My lord.
You're happy now? Okay. Then what else? When do you want it?
My lord, the affidavit filed by the Union of India, my lord. I'm yet to go through, my lord. Mr. Subedi was served a copy today morning, my lord. So
Not the state,
maybe
not the state, the Union of India.
Union of India, my lord.
You have to go through the state's affidavit or Union of India?
Union of India's affidavit, my lord.
Okay. Then I think you'll have to make some corrections there. What did I say in the beginning part? Mr. P. Nair said. Okay, filed by the state respondent. Instead of that, filed by the respondent numbers 1, 8, and 9. But the rest is okay. List this matter again when?
My lord, could it be after the Easter holidays, my lord? If not inconvenient on the 2nd of May, my lord.
What do you say, parties? 2nd of May? List the matter on 2nd of May. List the matter again on 2nd of May 2025 as paid for.
I'm sorry, my lord, I could not get tickets, my lord, to come, my lord. That's why I'm here to
it's
be seen, my
It's
lord.
okay.
Deeply obliged.
Item number 5.
Lordship, in this case, there has been compliance with the legal representation which has been filed. So there has been compliance with the legal representation which has been filed. So if the matter may be withdrawn.
Compliance of what?
Your Lordship, the concerned authorities, the local councils had issued a notice to the petitioner to vacate his home and to stay at Tong Trai Bethel Camping Center for a period of 5 years. So against that, legal representation had been filed, stating that it was arbitrary and against the Constitution. And they have filed a reply to the said representation stating that they will not pursue the matter and that he has liberty to stay at his own home. So since there has been compliance with the legal representation, we pray for withdrawal of the instant writ petition.
So you've got the relief.
Yes, Your Lordship.
I think we'll say that in that line. Mr. Jonathan Lalrin Kluanga, learned counsel for the petitioner, submits that the petitioner has got the relief which he has sought for and therefore would not like to pursue the matter any further. We'll stop. Mr. Benjamin Lalthamwana, learned government advocate, appearing for the state respondents, has no objection to the prayer. In view of above, the writ petition stands disposed of as withdrawn.
Yes, Your Lordship. You'll be obliged.
Obliged.
Yes, part 1 is over.
Yes, so
What else remains now?
Part 2, item 2.
Who is ready? Part 2? Anyone ready?
Mr. Babuya is here.
Huh?
Mr. Babuya is here.
Borboya is there?
Yes.
Okay. Which item?
Item 2.
Huh? You have come for which item, Mr. Borboya?
Item number 2, I think, Your Lordship. Hearing list.
Item number 2,
Yes.
criminal.
Yes.
And who is for the state? You ready?
Lordship, I'm not ready, of course. Mr. P.D. Nair is the advocate for the particular case and he
I
requested
see.
me to He did not get the flight ticket, so he requested me to fix it on 2nd of May. Earlier he has done one case.
What was the date? 2nd of May?
2nd of May, he said.
My lord, I was disconnected a bit, my lord. But I could not, this matter would require physical hearing, my lord.
What was the date we are giving you just now?
My lord, 2nd of May, my lord.
2nd of May. So we'll go on that day?
My lord, my lord.
Okay.
That will be
As
convenient.
paid for by Mr. P.D. Nair, Learned Counsel, for the appellant. This is the matter for hearing on 2nd of May, 2025.
Deeply obliged.
Then what else remains?
Finished. All hearings are
Hmm.
finished.
There were two matters fixed for Friday. I don't know, councils are not interested. Anyway.